Distinguished guests, ladies and gentlemen, welcome back. Now, let's move on to Plenary 4, key takeaways from a discussion on the merger working group products. We would like to invite the moderator of this session, Ms. Teresa Kininichkova from ICN Merger Working Group co-chair, and the speakers she would like to invite. Please come to the stage and have your seat. Please welcome her with a warm round of applause.
Thank you so much for the introduction. So I would like to invite representatives from each of the BOS 4 and BOS 8 sessions. So we should have one speaker or per session to summarize the key takeaways from the discussions that took place in the various breakout sessions. And I see them already arriving on stage, so that's great. Thank you. So good morning, everyone. My name is Teresa Kininichkova. I'm from the European Commission's DG Competition. And today I'll walk you through this plenary session where we will discuss the key takeaways that were discussed during the breakout sessions on the ongoing merger working group products, as well as a couple of additional topics. So first of all, I would like to say thank you to all of you who participated in BOS 4 and BOS 8. We had several groups where very interesting discussions were going on, and I have to say on behalf of the merger working group co-chairs, this is very valuable and we very much appreciate all the input that was shared. Because as you know, we're revising currently a number of ICN recommended practices chapters. And this workshop was also one of the channels that we wanted to use to get some insights from authorities as well as NGAs from around the world. But perhaps before we get to the points that were discussed in these breakout sessions on the RP chapters, I would like to first hear from Jessica, who had a very interesting discussion yesterday on the topic of gender-inclusive competition policy. So Jessica, would you mind sharing a few points that you discussed yesterday? Thank you.
Yes, thank you, Teresa. And not to sound repetitive, but first and foremost, I'd like to thank the TFTC and extend my gratitude for their exceptional efforts in hosting and organizing this event. It's been truly a great experience. I also want to thank my fellow merger working group co-chairs as well for their contributions in setting up and organizing the event. I think we've had some insightful breakout sessions and plenaries on some important topics and discussions. Notably, I'd also thank my excellent facilitators on the gender inclusive competition policy breakout session, Ms. Patty Brink and Ms. Umang Kananwal. Their efforts, I believe, sparked a very important conversation that we hope will continue beyond this workshop and continue to become a key consideration for authorities to continue their discussions in the future. I'll try to be brief. We only had a short 30 minutes with the session, but I think we had a lot of lively discussion to recap. Maybe first, we started off the discussion talking about how the relationship between gender and competition has remained largely unexplored until fairly recently. We talked about the OECD's efforts with the Canadian government along with the Canadian Competition Bureau that helped launch the OECD Gender Inclusive Competition Toolkit, as well as the policy project we discussed a little bit as well. We also discussed a little briefly the purpose of the toolkit and how it was aimed towards developing guidance for competition agencies and helping equip competition authorities with the knowledge and tools necessary to help incorporate gender considerations into their work. I think that the key takeaway from the breakout session is that we don't believe this is sort of a new way of thinking or changing our existing framework, but rather recognizing that for a while competition policy has been considered through a gender neutral lens, focused on the average consumer rather than it's much deeper than this. I think we discussed sort of understanding the consumer and who the consumer is and who is being harmed and how. Whether there's specific groups that may be impacted more adversely, whether there's other factors to consider as well, whether that's race, ability, income, other characteristics of consumer behavior. I think another key point as well was that this encourages competition authorities to consider how a range of diverse and disadvantaged groups may be disproportionately impacted by anti-competitive behaviors and how competition authorities can maybe better account for consumer characteristics going forward. I think there were also sort of three themes to take away as well that were highlighted in more depth. One being on the data gathering side, on the competitive analysis side, and the authority decision-making side. A few points for each. On the data gathering side, we talked about how data needs to be disaggregated to better understand how diverse groups are harmed. We talked about companies' use of data profiling and how that should be examined. Maybe surveys could help better understand differences in consumer behavior across different genders or other characteristics as well. On the competitive analysis side, we talked about how it should be looked at through a gender lens and whether firms may be or how they might be targeting a specific gender in specific product areas. And that maybe the way we look at substitutability is not necessarily reflective of how all consumers view it. And then one quick point just on the authority decision-making point, we discussed how this should be informed through inclusive stakeholder engagement and how authorities should have diverse decision makers. On top of that, we also had an important discussion on labor markets and women as consumers and also women as workers. I think Patty from the US DOJ raised a good case example that I think was timely and beneficial to the discussion, which was they recently blocked the United Health's acquisition in the home health and hospice provider market and talked about how this transaction threatens to not only negatively affect care for patients, but also hospice nurses, who we discussed are most likely women employees. In this case, the competition between the two companies benefits the skilled nurses who provide these services, and the merging parties identify themselves as their biggest competitors, so including recruiting campaigns and hiring as well, which was a point to say that nurses who provide these services receive better wages and employment terms because of this head-to-head competition, and as a result, this would eliminate a competing employer and deprive nurses of not only wages, but also employment terms that they favor. I'm sure I'm missing a lot, but I think I'll leave it at that, and then I think we came full circle to end our discussion the way we started it, in that we reminded everyone the importance of reading the OECD Gender Inclusive Toolkit and how we can continue to think about this in the future and how this can deliver a more effective competition policy. Thank you.
Thank you so much, Jessica, for this great summary. And indeed, I participated in that session, and I have to say that it was a very interesting discussion. At the same time, Group 1 yesterday in BOS4 discussed the RP chapter on the use of market shares, and I would like to invite Anne-Sophie from the French Autorité de la Concurrence to share with us what were the main points and key takeaways that you discussed. Thank you.
Thank you. Good morning, everyone. This breakout session about market shares and market concentration was the very first discussion about the use of these these elements in merger reviews in the context of the revision of the RP chapter of 2008. We started off by learning about how market shares and market concentration, such as the measures such as the HHI index, were used by different agencies as a starting point to assess the risks entailed by a merger. So we had discussions notably with the FTC DOJ, the COMESA, the Bundeskartellamt, and the Japanese Fair Trade Commission. What we learn is that agencies use presumptions. The presumption that a merger resulting in a substantial increase of market shares and/or market concentration constitutes a threat to competition. But likewise, some agencies will presume as well that a merger between parties with low market shares is unlikely to present concerns. And that's what we would call a safe harbor system or approach. So in a way, market shares and measures of concentration become a kind of sorting instrument between cases we would consider as harmful and cases which would be unlikely to present a threat to competition. We then discussed about the challenges raised by the use of these market shares and measures of market concentration. For the parties, it is challenging, of course, to find reliable estimates of their market shares and those of their competitors. And also for the agencies, it's also difficult to obtain reliable data, and agencies might have to, once they receive the data from the parties, might need to question the market as well to be able to check out that data. But more importantly, throughout these discussions, we mentioned the fact that there are situations where you can question the relevance of market share presumptions. Competition issues are not always reflected in market shares or measures of market concentration. For example, when you're dealing with fast evolving markets or markets already strongly concentrated, or markets where market shares can shift and change rapidly. And on that point, we had the example of bidding or tender markets, where competition is not a continuous process. Its competition actually takes place each time a tender procedure is opened. We then went on to discuss about the way to calculate market shares, which of course we all know is not always an easy matter. And market shares are based on properly defined product and geographical markets, and they should be based on measures of economic strength. So it's important to consider exactly what are the right metrics to use. And thinking about that, there's one area where it's not always easy, and that's in the field of digital sector, and that's of course an area of challenge. For example, if we look back at the hypothetical we all examined the other day in the music streaming sector, I mean, should we look only at revenues? Should we, for example, look as well at the number of viewers or people using those streaming platforms? We also have the issue of two-sided markets and platforms. Should we look at the metrics on both sides of these markets? Have other examples, for example, on local markets. How do you assess market shares in local markets? And you can have the example in the healthcare sector, or you could look on the side of the hospitals, or you could also look on the view of the patients. We further mentioned different types of metrics you can use in different types of the cases and markets. We then concluded the breakout session by discussing about the types of arguments that you use to rebut presumptions. Because of course these presumptions can be rebutted. So we went through these different elements, and the general impression is that what is important is to look at how the market works and where really competition takes place. And so we all agreed on the fact that if market shares are a useful indicator, they are not determinative. Thank you.
Okay, now it's working. Perfect. Thank you so much for that summary, Anne-Sophie. And still staying with the discussions of yesterday, I would also like to hear from Joel about the discussions that took place in the breakout sessions on the RP chapter on counterfactual. If you could share a few points that you discussed. Thank you.
Thank you. So with the counterfactual being, I was sat down over there 30 seconds ago, and I'm afraid I don't have extensive notes in front of me. That's what we're working from. So with respect to the counterfactual, we focused on two areas. One, the counterfactual in terms of the competitive assessment, and then secondly, the specifics around the failing or exiting firm. So on the first element, there was recognition that the counterfactual is treated in different ways by different agencies across the world, focusing in particular on whether you have a specific section on the counterfactual within your process or decision making, which, for example, the UK does, or whether you fold the counterfactual assessment into your more general competitive assessment, such as in our panel we had Kenichi from the Japanese Fair Trade Commission talking about how that worked within their process and decision-making steps. And then in understanding the counterfactual, there was a clear recognition that you start generally from the position of the absent the merger, the pre-merger conditions of competition continuing, and that's the kind of standard to work from. But what that doesn't do is necessarily stagnate or ossify the market as it is on the day that you begin your investigation. And that can take account of things that are likely to occur within that market as it develops. Even under pre-merger conditions of competition, even without a change to the market can develop going forwards. And in those developments, we discussed time horizons in particular, with the recognition that often people are looking over a kind of 2-year time horizon when they're thinking about the counterfactual. But in the last few years, that time horizon has developed, particularly as people have started to think about more dynamic markets, markets with innovation, as we talked about yesterday in the hypothetical. And that time horizon has and can stretch out into what you might call the medium term, so the kind of 3 to 5 year provision. And that was highlighted in some cases, including in, for example, the pharmaceutical sector as well, where you might look at pipeline products that aren't going to come to market for a period of time, and that might be your counterfactual. The other element around the counterfactual, and it also links into the failing firm, is when you have large external events which can impact where you are now versus where you might be in the future. So the example that was raised was the COVID-19 pandemic, and in particular in the context of airlines, how if you were assessing an airline merger during or shortly after the pandemic, by focusing on what the conditions of competition were at that time, that may not reflect what true competition will look like in kind of 3 to 5 years' time. And that was an example that was used across multiple jurisdictions. We had NGA from Italy, Gianluca, I'm not sure if he's in the room, I can't see him, there he is, hands up, talking about the European Commission and the analysis they've done on the counterfactual, but it was also reflected from Celestine from Singapore, talking about their own airline merger as well. Using that to then look into the failing firm, I think it was recognized that there's a pretty common framework around thinking about whether the firm is actually failing and the analysis that you need to do, and there being a pretty high bar to that, getting kind of across the threshold for that element. And some jurisdictions have the failing firm as an actual kind of separate defense, and again, some fold it into a kind of counterfactual competitive assessment section. So having thought about whether the firm is actually failing, looking at financial accounts, projections, things that the firm might have done in the past to ensure that it has taken kind of every possible step to rebalance and reignite the business. Then looking at whether there were alternative, more competitive purchasers of the firm, and what potentially a sales process has looked like, looking at the documents around that, and thinking about essentially whether the firm has decided to sell to the acquirer on the basis that that's the best price. There wasn't a full sales process, and so actually you don't know what the counterfactual would have been absent the transaction taking place. The final piece on failing firm is to take that one step further and not just think about the whole firm exiting, but what if you had, for example, flailing or a weaker competitor narrative, so not the full exit, and recognizing that often that is taken account of in the competitive assessment itself. But then secondly, you might have exit of a particular division of the firm, or you might have an exit not based necessarily on just financial failure, but more strategic decision making about where you might exit a particular market, for example, because the cost of supplying and continuing to supply in one geographic location or one particular market means that there isn't capital and investment available for a market in a different jurisdiction or a particularly adjacent set of technologies. And so that strategic exit is another element to the exiting firm which would be considered. But again, needing to spend quite a bit of time looking at the documents, understanding what's actually happened with the business to date and whether that rationale is something that was actually there pre-merger and not driven by the prospect of a merger. I think the piece that probably came through most strongly was with respect to both the counterfactual and the failing firm. They are rooted in the evidence from the firms themselves and understanding, again, the dynamics of the market. We probably say that in every breakout session across everything. I heard Anne-Sophie say it with respect to market shares, how the market actually works, what the companies think, what the documents. But I think it's fair to say having a relatively high bar, particularly on that exiting firm piece, was quite a common thing.
Thank you so much for that summary, Joel. So that brings us to the discussions that we've just finished this morning. I know it was an early morning, but still we had 3 great breakout sessions on very important topics when it comes to merger control, and all related to the ongoing revision of the RP chapters. Perhaps to start with my group, so in group 1 of BOS 8, we discussed the topics related to unilateral effects in horizontal mergers in particular. And we had a very diverse panel where we heard from experiences from around the world, including from academia as well as enforcers, of course. Given the huge number of theories of harms that you can have in unilateral effects cases, we had to pick some topics, so it wasn't a comprehensive discussion on the entire chapter, but I think we picked some very interesting topics that are perhaps new in the chapter, or where authorities have moved their practice. So we started off the discussion with the topic on entrenchment theories of harm, and we discussed whether in fact these are different to, let's say, more traditional theories of harm related to creation and strengthening of a dominant position. Indeed, the key takeaways on this topic are that perhaps there is not a great leap in terms of change from the current or the well-known theories of harm on strengthening of dominance and the entrenchment theories of harm. But the context is different. So in the context of new markets, in markets in digital as well as non-digital industries, when we talk about ecosystems, really these are the types of deals where a merger may lead to an entrenchment of an already dominant position. This can also result in a dominant firm acquiring a competitor, which then ultimately deprives the rivals of network and scale effects. We see these theories of harm also when it comes to acquisitions of nascent and innovative players. So we heard that experience both from the regulative perspective as well as academia. And then we moved on to the topic of non-price parameters of competition. So this was already discussed also on day one in the plenary, but it's important to say that the revised RP chapter on unilateral effects really puts greater emphasis on the fact that theories of harm are not limited to just price effects. So we spent some time discussing this, and we heard experience from agencies applying theories of harm also to non-price elements of competition, especially when it comes to cases dealing with dynamic competition. And we see factors such as innovation, choice, quality in various elements, and variety to be explored across the theories of harm. So there is not a single theory of harm that would be dedicated to non-price effects, but we see this across the theories of harm, whether it's creation and strengthening of a dominant position or entrenchment, elimination of an important competitor. And we've heard that perhaps in the past the focus was on price because this is something that's quite factual, it's quite mathematical, and you can calculate the impact easier. But indeed, with markets evolving, we see more and more regulators addressing harm to non-price effects, and we see it also across or at different stages of the assessment. So whether it's taking into account these factors at the stage of defining markets or at the competitive assessment stage, as well as when it comes to remedy discussions and remedy proposals. Of course, the assessment is case specific, and this was very much the agreement in the room. And linked to that, we then move to the important topic of evidence, because you can have a great theory of harm or thinking about how a case or a merger can harm competition, but of course you need to have your assessment grounded in reliable evidence. And we heard also from the Taiwan FTC their experience of using different types of evidence to show impact on non-price parameters of competition, on innovation. And it was mentioned that indeed authorities need to consider various sources of evidence, whether it's public statements, strategic plans, information contained in internal documents, in addition to views from competitors, customers, or other stakeholders. That, you know, in some cases, of course, use of quantitative evidence might be difficult. So then it's also important to rely on other sources of evidence. And then we move to discuss a bit theories of harm or mergers that eliminate a potential competitor. My takeaway from the discussion was that indeed some agencies look into these kind of effects, but it's not that this happens on a daily basis. So still, you will probably see a lot more cases where the elimination of actual competitor head-to-head competition is the result of the merger. But it's important to keep in mind that in some markets specifically, a merger can really harm competition by eliminating a potential competitor, and this could be either an actual potential competitor or a perceived potential competitor. Yeah, I mean, when assessing these kind of effects, it's important to really assess what value the potential competitor brings to the market. If it's a market where entry of other players is highly unlikely, so there are several parameters that authorities need to consider. And yes, I mean, in some jurisdictions where you also have a court-based system, it was also mentioned that the importance is then also to persuade the court that really the case will lead to elimination of a potential competitor. And then final two topics that we discussed, which are also, well, one of them is explained also in the chapter, is how can a merger harm competition when it leads to an increase in purchasing power. And we heard examples from the merger in the supermarket sector, and how mergers that lead to extended market power at the supermarket level can harm competition in a way that the purchasing power of these supermarkets gets to a stage where suppliers are or may be compelled to absorb price differentials through contractual terms. And we have also heard the examples from labor markets, which I mean, they were already discussed also previously at this workshop, but really considerations are given to the fact that reductions in competition among buyers has a negative impact on working conditions. It can also lead to lower investment, less innovation, and distortions in markets which sometimes are difficult to see at the first sight when you look at the merger. But indeed, authorities should pay attention to these potential negative effects as well. And finally, we also touched upon the issue of countervailing factors. So whether there are indeed some market constraints that may offset the potential harmful effects of a merger. And from the discussion, it really seems that especially when it comes to countervailing factors such as buyer power or efficiencies, it's really in rare cases that these are sufficient to offset the negative effects. And perhaps authorities also need to be cautious when accepting or when considering to accept arguments on buyer power, because this can really encourage companies to get into an arms race. So we've heard from regulators during this session that indeed in many cases it would not be sufficient to accept an argument on buyer power or efficiencies, but it's something that regulators also need to assess in their assessment. And with that, I would like to pass the floor to Marion, who was in breakout room 2 and discussed the RP chapter on on coordinated effects.
Yes. So yes, on the breakout session, we discussed coordinated effects in merger control. And I think the starting point of our discussion was that agency actually relatively rarely pursue a series of harm on coordinated effects. And we brainstorm on what could be the reasons why that's the case. The first reason that was brought was the complexity of the reasoning compared to unilateral effects. And we focus in particular on the point that in coordinated effects, there is this idea that we need to show that the participant would have the incentives to follow rather than deviate from the coordination, and that there should be somehow some mechanism to detect and deter from deviation, which may not be easy to establish. And then we had a discussion within the speakers on whether it should be for the agency to prove that, or whether it shouldn't be more the burden of the companies to prove that they don't have such incentives. The second reason was discussed on why maybe agencies do not pursue this theory of harm so often is that it may overlap with unilateral effects in some cases, and we have had an increased use of unilateral effects, including in more what we call non-dominance cases, and that often actually the coordinated effects are brought in on top, in addition as a complementary theory of harm. I think importantly what we discussed is that maybe it would be good that it changes over time and that more of those cases are brought. And one of the reasons why is that we see increased concentration levels across the board at global level and in many jurisdictions, and that maybe in light of these specific facts we should more often consider those series of harm. And then another perspective in the panel, in particular from the NGAs, was that actually maybe it was a good thing that we didn't have so many of those cases, and that we should maybe focus the cases on what is the most classic and obvious cases of coordination. And when I say classic cases, is because usually we see that a merger may increase the risk of coordination when it's transparent, when it concerns commoditized or homogeneous goods. And so there was a call from the AGS to probably try to focus on those simpler cases. But at the same time, and in particular the US DOJ brought that in their jurisdiction, and that's the case in other jurisdictions, we're actually bringing coordinated effects cases in very different settings than those classics one. And Patty Brink brought the example of a case in the US in the book publishing industry. So that was the second point. And then we discussed a bit as well the fact that now that we see also in the industries, at least some industries, an increased use of pricing algorithm or artificial intelligence, and we discuss whether that may lead going forward to also more cases with risk of coordination. I think there was a sort of consensus that yes, that may well be the case. And then the question was more, but how would we prove that the merger is changing something if there is already pricing algorithm? And then there was a debate whether the mere fact that you reduce the number of players couldn't just be in itself sufficient in a market that is already conducive to coordination to bring such a case. And then there was a last word on the fact that merger control really has a key role to prevent the creation of those structures that are conducive to coordination, and that certainly agencies shouldn't have in mind that we sort of wait for a cartel to come and then act upon a cartel, but that merger control is a powerful tool to just not get there. So I think that's a summary of the discussion. The last thing maybe I want to mention is that, so we are drafting this update chapter on the recommended practice chapter on coordinated effects, and we have launched a second and final consultation just before the workshop, the same for the unilateral effects chapter. And so there is a deadline for you to provide comments. So when I say you, it's really agencies and NGAs. You should also have received it. If you want to provide comments, the deadline for coordinated effects is mid-December, and for unilateral, I think it's mid-January. So, yeah, feel free to just send the comments to us. Thank you.
Thank you, Marion. Indeed, I mentioned this at the breakout session, but it's probably important to say here in the plenary where we have everyone in the room for the unilateral effects. Indeed, the second consultation runs until the 10th of January, and this is the second and last consultation. So it's really your chance to read it and provide any comments that you may have from the various jurisdictions and perspectives, and your submissions will be very much appreciated. Thank you so much in advance. And finally, I would like to turn to Omar to summarize the key takeaways from the discussions that were held on the RP chapter on market definition.
Thanks very much. Yes, so I was the moderator of the third breakout session on market definition. We had a good discussion as well. We made it clear to the group at the outset that it was happening in the context of work that was being done to update the market definition section of the recommended practices for merger analysis. We flagged for the group as context for the discussion that one of the updates that was being considered was to reduce the emphasis in the RP on the hypothetical monopolist test, and that helped inform the discussion in our breakout session. That recommendation came from the Competition Bureau's work in benchmarking member agencies' guidelines, and in doing that benchmarking exercise, it determined that guidelines acknowledge that the hypothetical monopolist test or SNPs test might not be applicable in certain or all circumstances, And it compared that experience and observations with respect to guidelines to what it was seeing in the recommended practices, which have a relatively high emphasis on the importance of the SNPs test. So that was something that was the context for our discussion, that informed our discussion, and that I'll report on in part today. So what was the sort of outcome consensus of the discussions we had? There was a recognition that market definition was a very important factor in merger assessments. In some jurisdictions, it was legally required. We had a discussion about that. There was a broad recognition that it is a methodology. It's an important methodology, but it's not a necessary methodology or the only methodology that competition agencies can be using. That said, I think there was a consensus, or at least a recognition, that the SNPs test was important as a framework for informing market definition, that although agencies rarely run a full quantitative SNPs analysis for a variety of reasons, including cost, complexity, availability of data, that it helps informs an agency's investigation of an M&A transaction. It helps informs questions that they ask. It helps informs the information that they want to collect to make their merger assessment, so that it's by no means irrelevant. It's important, but not in the way that perhaps the recommended practices suggest that it is or ought to be used. There was also a discussion about general guidelines, flexible guidelines, whether or not there had to be a specific discussion about departing or having special rules for market definition in special contexts, special industries, digital markets, et cetera. But I think there's a view that general guidelines of broad application are helpful and desirable. And overall, there was general support for updating the recommended practice to reflect some of the feedback that the Bureau had been, the Competition Bureau in Canada had been observing in its assessment of member states' guidelines and the discussion in the room, so that directionally that was something that would be worthwhile pursuing, not getting rid of the SNPs test or the hypothetical monopolist discussion, but contextualizing it and limiting it and reflecting what agencies are actually doing in practice more frequently. And that was an update on my breakout session. Thank you.
Thank you so much, Omar, and everyone. And once again, thank you to everyone who participated in these breakout sessions. It was very useful for also all of us who are involved in drafting of these chapters. So thanks very much. And I think with that, we can close this plenary and enjoy, well, the final coffee break of this workshop. Thank you.
Once again, a warm round of applause to the moderator of all the speakers. Now, we have a 20-minute break. The refreshments are served outside the conference room. Next session will be started here at 10:50. 10:50. Please come back here on time. Thank you for your cooperation. Now, let's move on to next session, petitioners' perspective on process procedure tools and practices for effective management of merger cases. We would like to invite the moderator of this session, Mr. Salish Renyant, Competition Commission of Mauritius, and the speakers, Mrs. Sophia Hariri, Mr. Hitaki Uzumomiya, Mrs. Fang Yizhen, Mrs. Crystal Maharaj. Please welcome them with a warm round of applause.
Thank you. Thank you, everyone, for your presence in this last session of this ICN Merger Workshop 2024. So in this session, we'll be talking about tools and practices for effective and timely management of merger cases. As we all realize, mergers and acquisitions are time sensitive, and any delay in the assessment of mergers and acquisitions by competition authorities may have serious implications, not only for the transaction, but also for the market, and it may impact employment and even competition. So we all recognize that there's a need for us to manage merger cases in an effective and timely manner. From that perspective, we also understand that several competition authorities have worked to develop tools and practices to enable them to enhance their merger case management in terms of timeliness and effectiveness. But often, these tools and practices remain within that competition authority. And we, at the level of the ICN Merger Working Group co-chairs, we decided that it may be very useful for us to try to identify those tools and practices from various competition authorities, and we have launched a project in that perspective. So we basically aim to, through that project, to collect sort of a database of existing tools and practices for effective management of merger cases, and at the end of the project, to produce a report whereby these tools will be made available to the ICN community. They can obviously then use this report to benchmark their own merger case management system, and also to inspire themselves from these tools and practices which they want to implement at their own competition authority. So as I am saying, this is an ongoing project for the ICN Merger Working Group. And at this point in time, we have already sent an email to all NCA members of the ICN community requesting their input in terms of tools and practices they have implemented in their authority. I would encourage each of you to look into this particular request and to give us maximum input so that we, at the end, we can go through all those tools and produce and expose a database to the ICN community for the enhancement of merger case management. We also recognize that the perspective of practitioners on such tool is very important. Indeed, in the previous ICN annual conference, we had a similar session on tools and practices for effective management of merger cases. And we had very insightful ideas from practitioners from private practice. And we say that this workshop would be also interesting to have a discussion and have practitioners' perspective on tools and practices for effective management of merger cases. So we have today with us a diverse panelists who will share their experience on tools and practices as practitioners and also from an agency perspective. Without any further delay, I will introduce to the panelists. So starting from my right, we have Sophia L. Hariri, an NGA from France. She's a lawyer at Depardieu Bocas Maffei and has more than 15 years experience in advising on competition matters. Then next we have Mr. Hideki, an NGA from Japan. He is a partner of Japan-based law firm, Mori Hamada Matsumoto. He has experience in competition law in Japan and also advising on cross-border transactions. Next, right, we have Ms. Fang Yizhen, who is an NGA from Taiwan. She's a lawyer and partner at Baker McKenzie Taipei office and serves as vice chair of the Competition Law Committee of Taipei Bar Association. And then we have Ms. Christelle Maharaj. She's Senior Legal Counsel from Trinidad and Tobago Fair Trading Commission. She has been practicing for 13 years and has been with the Commission for 4 years. We were supposed to have a fifth speaker, but unfortunately, due to unforeseen circumstances, he has not been able to make it. But he has sent us, nonetheless, his input, which we will be using for the project. So without any further delay, I will invite Sophia to give us an expose of her experience with dealing with tools and practices for merger case management. Up to you, Sophia.
Thank you. Hello, everyone. I'm delighted to take part in this session and share with you today my perspective as a French practitioner that has been submitting several filings to the French competition authorities as well as to the European Commission. How to reconcile the merger control procedure with the time frame from the transaction is in fact the question that we are confronted as councils. The merger notification process can be long, complex, and sometimes burdensome for companies. And I'm happy to notice that reducing the administrative burden has become a priority for competition authorities in recent years. Preparing for this session led me to ask myself the two following questions. First question, what are the tools or practices, if any, developed by competition authorities, and in particular here, the French Competition Authority and the European Commission, that ensure effective and timely management of merger cases? And the second question is, are there any need or room for improvements? And in order to answer these two questions, I thought it would be more appropriate not to draw up an exhaustive or to compile the various tools and practices implemented by these two authorities, but rather to focus on specific examples of tools and practices which have proved, in my view, to be effective in taking account the time-sensitive nature of merger cases. So there are tools which are applicable either to all merger cases, regardless of their impact on the market, some that are applicable to cases that raise no concerns, and others that may apply also to transactions that are more complex and then raise serious antitrust concerns. Turning first to the tools and practices applicable to all merger cases, I thought it would be interesting this morning to talk about the pre-notification practice itself. It is widely used in practice in France at the EU level, but I understand from my discussion with some of you this week that it is far from being the case in many jurisdictions. So basically it's an optional and confidential phase, which is highly recommended, although non-binding. And as its name suggests, this phase essentially consists of informal exchanges between the competition authority and the parties on the basis of a draft notification, and during which the authority checks the information provided, carries out its analysis, and asks questions to the parties. So I would say it's a phase that is positively considered by the parties and practitioners, and I guess also by the authorities, as it allows both sides to fully discuss all the issues without being constrained by the formal examination deadlines, which are in practice quite short. In France or at the EU level, it's 25 working days. Some of my colleagues, practitioners, may consider that the pre-notification phase runs against the objective of effective and timely management of merger cases. Insofar, it is not limited in terms of duration, and it can also have a significant impact on the time frame. Because in practice, the formal notification is only going to take place when the authority has finalized its analysis and has considered that the case is complete. So yes, regulating the duration of the pre-notification could indeed be an interesting option to avoid such a pitfall. But I think that one should also consider that the pre-notification practice has to be considered in relation to other tools and practices implemented actually by the French and the European authorities in order to simplify and speed up the review of certain transactions. So, as some of you know, these two authorities have made major efforts in the recent years to simplify merger control procedures, and by involving all stakeholders through public consultations, and by creating a simplified procedure for obviously non-problematic cases. So in particular, mergers with no overlap, either horizontal or vertical. And this procedure results in simplification. Simplification in terms of preparation of the notification with a reduction of the information to be provided. Simplification in terms of time required for examination. For example, in France, the clearance decisions may be issued before the legal deadline of 25 working days. So in practice, more or less 15 working days. And simplification as well in terms of content of the clearance decision itself, which is more or less a brief description of the parties and their activities. And both authorities, the French and the European, have recently continued their efforts to simplify the notification procedure by considerably extending the access to the simplified procedure under merger control. For example, for the European Commission has extended the categories of cases treated under the simplified procedure, and now it covers transactions where the combined market shares are below 50% and the HHI delta is below 150. But the European Commission also has introduced interesting flexibility clauses that gives it the discretion to treat additional cases under the simplified procedure in certain circumstances. For example, where you have like horizontal transactions with market shares between 20 and 25%, or vertical transactions with market shares between 30 and 35%. And for such transactions, the European Commission also introduced a tick-the-box notification form with limited information required from the parties. The European Commission also implemented a super simplified procedure for certain cases, in particular merger cases that give rise to no overlap. And for such cases, pre-notification is no longer highly recommended, and the clearance decision may be issued within 15 working days. As for France, the French competition authorities has similarly extended the categories of case treated under the simplified procedure. And for example, where you have as well transactions involving market shares less than 50% and an increment which is less than 10 percentage points. And it has also quite recently been experimenting a new approach vis-à-vis cases that benefit from the simplified treatment. And under this fast-track procedure, no pre-notification is needed. No questions during the investigation phase are expected, with bearing exceptions, of course. And a clearance decision can be expected within 15 working days. But there is one condition, of course, for the parties to benefit from such fast-track procedure, that the notification really must deal with all the markets and segments that have been consistently identified in French or EU decision-making practice, which includes also markets where the exact definition has been left open. And I have experienced very recently this new approach, which resulted in a case being managed, according to me, in a timely manner, with a clearance decision issued earlier than expected, in particular almost like 2 months ahead of the initial time frame, which took into consideration the pre-notification phase we talked about, so which is not that common, I must say, to obtain a clearance decision that earlier in the process. What are the pros and cons of such simplified treatment for this specific merger cases? As for the pros, I would say definitely saving time and money for companies, and I guess for the authorities as well. They can then better allocate their resources to more important and complex cases. And as for the cons, well, the provision of information may still remain burdensome on specific cases. When we talked about the fast-track procedure, for example, in France, which is being experimented, the party really must provide information on all plausible markets, including markets for which the exact definition has been left open, so which could need lots of work for companies to meet such criteria. And as for example, at the EU level, the tick the box form may not that be in practice that well adjusted to all cases, particular cases involving lots of or several parties or several segmented markets. I was talking about like more simple cases, merger cases, but problematic cases are not left out. Although they cannot benefit from the simplified procedure, it does not mean that they cannot be reviewed effectively by a competition authority. And for this type of complex transactions, the pre-notification phase that I referred to can be very useful. But it seems to me that there are also currently some practices or tools that can enable the authorities to manage efficiently such cases. I'm thinking in particular of the fix-it-first tools that we discussed last Tuesday, I think, in one of the working groups. So as you may know, in substance, for example, for structural remedies in a complex merger case, the acquirer can notify the transaction by presenting straight away a buyer for the business or the business or a part of the business whose acquisition is raising concerns. And in such a case, then the authority assesses the impact of the merger, taking into account the planned divestiture. What are the pros and cons, once again, for such remedy tools? I have experienced 2 cases reviewed by the French competition authorities with fix-it-first remedies covering both structural and behavioral remedies. In fact, it was a license agreement. As for the pros, I would say that a fix-it-first solution is advantageous for the notifying party insofar as it can negotiate the divestiture of the assets outside, I would say, the constraints related to the existence of commitments undertaken before the authority, which may then encourage wait and see or opportunistic behavior on the part of potential buyers. And fix-it-first remedies may also make it possible to reduce the time required to implement the commitments and then also to reduce the uncertainty associated with them by eliminating the period during which the purchaser must be identified and approved following the conditional clearance decision. And as for the cons, it is also that requires a great deal of forethought on the part of the companies. The preparation of a file that is as complete as possible with an assessment, of course, of the remedies, proving that they are effective and proportionate to remedy the harm to competition. So there are definitely, at least at the French and EU levels, several tools and practices that enable effective and timely management of merger cases. Then, of course, I didn't mention other tools today. And since, in my opinion, things can always be improved, I guess that some of these tools may still be further improved. As a practitioner, of course, limiting even more notification seems to be an option. However, once again, from a pure practitioner's perspective, for transactions requiring several merger control clearance, I think it does not solve the potential differences in the way a single case is going to be handled by the various competition authorities having jurisdictions, and that may have an impact on the time frame. Of course, I'm not talking about the legitimate differences between jurisdictions in terms of analysis, because there are specific features for each national market, but I guess there is no doubt that the current ICN work products on these tools would, I mean, at least procedural ones, could solve, at least in part, these possible differences.
Thank you, Sophia, for this very useful insight and feedback. There are lots of it, so we'll try to incorporate it in our project, obviously. And now I invite Mr. Hideki to provide his perspective, which I understand also relate to notification and communication. Mr. Hideki.
So this is a great opportunity for me to speak about the practice in Japan. So as a private practitioner, I have been handling numerous merger filings before the JFTC for over 20 years. And based on my experience, I would like to speak about effective management of merger cases based on my practice, mainly in Japan. And first, I'd like to speak about practices before speaking about the JFTC's practice. I'd like to briefly mention the number of cases reviewed by the JFTC. The JFTC increased the turnover thresholds in 2012, so 12 years ago. And such amendment of thresholds reduces the number of cases reviewed by the JFTC per year from around 1,000 to 300. It allows the JFTC to focus more on important cases. Recently, the JFTC introduced a quasi-size of transaction threshold, and it has been more active in conducting ex officio investigations against non-reportable cases. I believe that the JFTC can use its resources more in such important cases because of the amendment of thresholds 12 years ago. On the JFTC's practice, like practice in Europe, key point to note on effective management of merger cases would be active communication, including pre-filing consultation between the JFTC and the parties. The JFTC is generally open to communicating with the parties at any stage of review process. The JFTC's flexibility in communication with the parties is publicly announced. The JFTC's formal review process is something like the other agencies, like yours, 30-day phase 1 and 90-day phase 2. But in Japan, pre-filing consultation is heavily used to avoid unnecessary phase 2 review due to running short of 30-day phase 1 review period. Recently, the number of phase 2 review is just 1 or 2 per year among around 300 cases being reviewed annually. We do almost everything during pre-filing consultation process, including discussion about market definition, substantive analysis, so merger assessment, and even on remedies. Case handlers at the JFTC are skilled to communicate with the parties to process the review in a timely, reasonable, and transparent manner. In sharing their impressions on substance and potential concerns with the parties, case handlers are mindful not to mislead the parties or to disclose third parties' confidential information they obtained through their market test. But they are basically frank and provide us with useful input so that we can address their questions or concerns at the right timing. Sometimes the JFTC's RFI looks too long and detailed, and thereby burdensome for the parties to respond compared to our understanding of the facts and issues. In that situation, we do not hesitate to reach out to the case team and ask to discuss to see if we can narrow down or put a priority on the questions and requests. It helps both the case team and the parties to have a common understanding and potential concern on the case, and makes the management of the review process more effective and efficient. Communication with the JFTC is also used to narrow down the scope of data which is necessary for the JFTC's economic analysis and of internal documents to be submitted. Sometimes the discussions and communications with the JFTC involves JFTC's economists and the parties' external economists. Further to the communication for the effective case management, I would like to mention a couple of important points in the JFTC's practice. The first point is safe harbor. There's no simplified review process in the JFTC's merger review. However, the JFTC provides a safe harbors in its merger guidelines. Safe harbors are provided for each type of mergers, i.e. horizontal, vertical, and conglomerate, by using market share and HHI. And the JFTC will not conduct a substantive review for goods or services that meet safe harbor criteria. Accordingly, safe harbor works to the review process focusing only on important areas. Of course, it helps us, parties, to reduce our unnecessary effort to prepare explanations about numerous minor goods or services. The second point is the JFTC's efforts to disclose the important cases. The JFTC publishes major merger cases every year, and any time when it finishes a review of important case. In addition, the JFTC publishes the list of relevant markets in the past cases according to industry classification. The list of past relevant markets helps us to determine the relevant market for the future transactions, and thereby to gather market share data which can be used to determine if safe harbor is available. The list of past relevant markets contains slightly different categories for some of the same goods or services defined at different years. This is because the JFTC has come to define the relevant markets more precisely, especially these days. Such information is also helpful to avoid unproductive discussions between the JFTC and the parties on relevant markets. So lastly, I would like to briefly speak about our practice of multi-jurisdictional filings, though it may not directly relate to the case management. As we regularly handle cases which trigger multi-jurisdictional filings, we compile thresholds of major jurisdictions together with their review timeframes based on publicly available information. We are developing a tool that allows us to easily determine which jurisdictions require filing by inputting the parties' financial information, such as sales and asset amounts. Of course, we work with local experts to assess reportability. It is always a challenge for us in analyzing reportability in jurisdictions which need to consider certain substantive elements, such as acquisition of control, especially joint control with minority shareholdings, market shares, and exemptions. Merger working groups templates on merger thresholds are useful for practitioners like us to conduct this screening efficiently. So it'll be helpful if they are updated and more agencies participate in the template. Thank you very much.
So we can see that even practitioners have their own tools that help them for effective management of cases. So we are slightly late, so I will now invite Ms. Fangi for her presentation. So we have strictly 10 minutes each.
Good morning, everyone. So I would like to share my views on the recent tools and practices developed by the Taiwan TFTC to ensure effective and timely management of the merger cases. I hope my insights contribute to today's discussions. Recently, the TFTC has taken several steps to enhance the efficiency of the merger case management and review. I will first outline these initiatives. First, in June 2023, the TFTC expanded its expansion criteria for merger review in cases where local effects are minimum. Specifically, if foreign entities establish a joint venture outside Taiwan without any operation within Taiwan, they are not exempt from a filing with the TFTC. Second, also in June 2023, the TFTC amended its merger guideline to broaden the situation that qualifies simplified procedures. This includes the transaction where the transaction occurred outside Taiwan and the transaction value does not exceed certain amount, and the transactions that meets the market share filing threshold, but the parties otherwise has minimum sales in Taiwan in the relevant markets. These changes allow the TFTC to direct its resources to the cases with a significant impact in Taiwan, while streamlining filings less relevant to the Taiwan market. Third, the TFTC has introduced an online filing system which allows applicants to submit all kinds of merger filing materials electronically. This change eliminates the need to physically deliver the documents to the TFTC before the office closes, as applicants can now upload their materials as late as 11:59 p.m. of the business days. It also enables applicants to monitor the review process online to make the review process more transparent and open.
Currently, around 70% of the filings are made through this online system. Fourth, since July 2021, the TFTC has also offered a pre-filing consultation service to further improve the efficiency and predictability of the merger review. This service allows the applicants to clarify whether a transaction meets the definition of the merger, whether the filing threshold is triggered. The applicants can also seek advice on the required documentations and procedures issues before making a formal submission. Now, as a practitioner, I would like to share some reflections on these tools and practices based primarily on the feedback from my clients involved in the merger review. First, the expanded eligibility for the simplified procedure and the exemption has been positively received by the companies, especially foreign companies. Previously, some companies occasionally expressed concern about the need to file in Taiwan when the cases there was limited relevance to the Taiwanese market. For example, establishing an overseas joint venture could trigger a filing in Taiwan even if the venture has limited operations in Taiwan. The recent TFTC's changes has reduced the burden on the companies and allowed the TFTC to contribute and focus on their resources on the minimum cases where local market will be impacted. Secondly, the online filing systems help save the time traditionally spent on exchanging official documents and submitted paper copies. This eco-friendly measure greatly enhances the flexibility and efficiency. And also, lastly, for the filing consultation system, it demonstrates the TFTC's well-intentioned goal of promoting the openness, transparency, and the predictability of the merger review. However, in practice, I find that the applicants in the large cross-border transactions are hesitant to use it. This is partly because that for this consultation request, the TFTC suggested that requests be made at least 10 working days before the intended filing day. For complex cases, the PFTC recommended the consultation request be made at least 20 working days. Additionally, these consultations are non-binding. So this is quite different from the pre-consultation service in Japan, as just shared by my colleagues. For cross-border transactions, and usually the transaction document will specify that a merger filing has to be made within certain time frame. For example, 10 days or 20 days of signing. These create time pressures that lead the applicants to bypass this consultation and proceed directly with filing. And also for transactions that must be kept strictly confidential, such as hostile takeover. Before the announcement, the applicants are also reluctant to use it. With that being said, in fact, in my experience, once a filing is submitted, the TFTC case handlers generally provide effective guidance to applicants to amend its filing materials as needed. As a result, the pre-filing consultation service are less critical for transactions where speed and confidentiality are essential. To conclude, the TFTC's evolving approach to merger case management and review has made a positive impact on the merger review in Taiwan. While there are areas where further transparency or openness could enhance the user experience, these initiatives meet the needs for the business and the stakeholders effectively. Thank you for your attention. I hope my reflections has contributed to today's discussions.
Thank you, Fanny. So one observation is that all our free NGAs seems to put quite importance on notification system and pre-notification mechanism as one of the tools that may either improve or, contrary to that, as an impediment to effective case management. Indeed, from our previous BOS also, a similar observation was happened. So it seems that our notification and pre-notification mechanism are quite important tools for competition authorities to ensure that there is effective case management, be it from the competition authority side or its impact for parties. So now we will listen to Ms. Christelle, who is from a competition authority, and she will give us her perspective of tools and practices, more so from perspective of a small competition authority. So over to you, Christelle.
Good morning. At the TFTC, with a staff complement of less than 10, a full-time legal of 1, myself, 1 investigator, having looked and reviewed at more than 40 merger applications since September 2020, a proud gun-jumping enforcement figure of 0. These are the practices that we find particularly helpful. And I'd just like to firstly endorse my colleagues' views of the practice of, during the entire merger process, engaging with parties to help them understand. There's also the practice of public consultation or stakeholder sessions. There is a session that the TFTC holds with regulators in the state sectors on a yearly basis, where we share common merger experiences, challenges to foster greater cooperation and to avoid duplicity of work, as well as any future legislative changes in the merger realm that may seek to disrupt the market. There is also an annual meeting held with public and private legal counsel, where we share updates in the merger realm, recent caseload that may impact their operations, the importance of spotting anti-competitive offenses in their merger review, and associated offenses such as interlocking directorship, insider trading, bid rigging or collusive tendering, how to spot signs of gun jumping, the importance of independently verifying data, and the importance of counsel not assuming the role of the TFTC in seeking to determine what is or isn't a merger. And there is also a specific slide dedicated to the treasure trove of competition law resources, where we highlight ICN's work, specifically training on demand, the competition fundamentals, merger investigations and remedies, and investigative techniques. We are also proactive in developing and building a merger repository. Now again, this serves us well for being a small agency with budgetary constraints. So we look at fields such as competitors listing by sectors, consumer contact information, information on the market, service and questionnaires by sectors, pricing trends, complaints about products, prices and qualities and services, whether companies are blacklisted, involved in previous litigation matters, a list of experts, case on precedent banks, as well as relevant newspaper and social media clippings. There is also the practice that we use of a secretarial certificate. So far too often we find legal counsel coming to us and making that determination what is or isn't a merger transaction for our purposes to review. And what we do to hold legal counsel and these parties accountable is have them attest or certify in the secretarial certificate that neither party will cease to be distinct after the merger. There'll be no transfer of goodwill or trademarks. There'll be no change in the beneficial ownership, and that the merger threshold requirements have not been triggered. This way, if the situation changes and there is a covert attempt to gun jump or evade the scope of the TFTC, we can hold them liable at the end. And we view this as an effective merger management practice. There is also the practice of people management, and it is important for continuous training and upskilling of staff for effective case management review, whether it's from the ICN, the RCC, the OECD, the IDB, OCAGE Brazil, or the European Union, from which the TFTC has well benefited from. there is also the practice in terms of thinking of deadlines. And yes, while it may sound old school, having 30 days to review a merger, it's helpful, say, for instance, to give parties specific timelines to respond to information requests, whether it's 7 days, whether it's 14 days. And we take the 21-day milestone to actually send the internal board paper to our director and board members. So this way now we have a 9-day window gap if further information is to be obtained. And although we don't have that notification tool, again, we employ the daily practice of monitoring continuously all local newspapers as well as social media feeds. And this brings me to the end of my presentation in terms of what we have employed at the TFTC. Thank you.
Thank you very much. Maybe I will ask one question to each of our NGAs here. So if there was one element that they would recommend that competition authorities must change to enhance their case management in terms of effectiveness and timeliness, what would that be? So only 1 point, each of you. Maybe Sophia, if you can start.
Well, as for France or the EU, as I explained, in my view, lots of efforts have already been provided into that direction. Well, I'm maybe thinking about using more digital tools could be helpful. I know that France, for example, has developed online merger notification since the last 5 years, but for specific cases, for example, cases where there is no overlap or in the automotive sector. So it's supposed to be a very simplified notification through a digital platform. But I'm not sure that in practice it is that well used. So maybe it could be you know, an improvement.
Mr. Heineke?
Yeah. So I basically am so satisfied with current communication with the JFTC, but I would mention about such communication. It would be more helpful for us to exchange the view of the theory of harm on the transaction being reviewed. So given the increased number of complex cases involving especially digital area, it is more challenging for us to identify the potential theory of harm. So it'll be helpful for us to have the more clear discussion as to the potential theory of harm in a more frank manner. That is helpful for us to consider the potential remedy in a challenging case. So, yeah.
Thank you. So, Ms. Mengi, any idea?
For the online checking systems to see the merger progress of the review, so it would be more appreciated if there would be more detailed status on the review stages, because sometimes we receive feedback saying that the status will be too brief or without any detailed information. And also, I understand that for some important or high-profile cases, the TFTC used several analytical tools to define the market. For example, like a pass-through rate analysis, regression analysis. So it would be appreciated if there would be more discussion or communications about the definition of a market during the review.
I would say communication is king. So board that communication caravan and bridge that disconnect in terms of information required for effective case merger management. So for competition agencies, whether it's a lunchtime fireside chat, infographics, podcast, TV and radio programs, newsletters, to merge or not to merge series, Competition 101 for Dummies, it doesn't matter. Just spread the word to actually build and promote more compliance in the merger realm. Thank you.
Very much. So we have nearly reached the end of this session. In fact, we have a certain announcement to make, but before that, I would like to seize this opportunity to thank our speakers for this very insightful perspective on tools and practices used by competition authorities, which obviously would be used as an input to our ongoing project. I also seize this opportunity to thank the Taiwan Fair Trade Commission for this excellent organization of this workshop, which I must say has been exemplary. Everyone must agree with me that the hospitality was to a very high standard in terms of logistic, be it in terms of location, even the food and the dinner, not to mention at least the singing by everyone here. And I'm happy to announce that the ICN Merger Working Group co-chairs have decided that we will conduct another workshop next year, so another ICN Merger Workshop. And I'm also happy to announce that that workshop will be held in Mauritius. So we have not yet fixed the date and the venue for that, but it is likely to be end of October or early November next year. And I will invite you all to Mauritius next year. So we will be providing more information in due course. But for the time being, we have produced a small video that we would like you to watch for the upcoming event.
The co-chairs of the ICN Merger Working Group are pleased to announce that the 2025 ICN Merger Workshop will take place in Mauritius, a tropical island located in the heart of the Indian Ocean. From its crystal clear waters to its rich cultural heritage, Mauritius sets the stage for connection, learning, and sharing for collaborative growth. Today, the Mauritian economy thrives on a blend of key sectors, including manufacturing, fisheries, tourism, information and communication technology, and financial services. Mauritius is considered a beacon of economic success in sub-Saharan Africa. Since 2009, the Competition Commission of Mauritius is playing an important role in shaping the Mauritian economy with more than 350 inquiries and 70 investigations. The Competition Commission also plays an important role at regional and international level. It is currently the chair of the African Competition Forum, the chair of African Heads of Competition Authorities Dialogue, and co-chair of the ICN Merger Working Group. The Competition Commission is proud to be hosting a second ICN workshop after having hosted the ICN Advocacy Workshop in 2014. Besides, the Commission has hosted several regional and international events.
As co-chair of the ICN Merger Working Group, it is an honor to invite the global competition community to join us for the ICN Merger Workshop 2025 in Mauritius. The workshop will be a unique opportunity to enhance collaboration within the ICN community and discuss pertinent issues around merger control while experiencing the rich culture of the island. Stay tuned for more details, and we look forward to welcoming you all in Mauritius.
The Competition Commission, shaping markets, furthering progress.
Thank you very much. Hope to welcome you all in Mauritius next year. Thank you.
Once again, a warm round of applause to the moderator and all of the speakers.
你看这样子哦。
Distinguished guests, ladies and gentlemen, the agenda for 2024 ICN Merger Workshop has now concluded. Now, we would like to welcome Ms. Li Mei, Chairperson of the Taiwan Fair Trade Commission, to deliver the closing remarks. Please welcome her with a round of applause.
Distinguished guests, ladies and gentlemen, as we conclude the 2024 ICN Merger Workshops, I would like to express my heartfelt thanks to each of you. Hosting you all in Taipei has been an honor for the TFTC, and it's your active participation that has made this event such a meaningful success. Once again, I would like to express my thanks to the co-chairs for their dedication to this workshop, and also to all the moderators, speakers, and participants for your contributions, which have made this workshop both inspiring and productive. Your contributions have been invaluable, and this success could not have been achieved without you. I would also like to thank all the TFTC colleagues for your hard work. It's your efforts over the past few months that have made this event a smooth and successful conclusion. Over the past few days, we have talked about many critical topics, from the impact of digitalization and globalization on merger analysis to the increasing relevance of innovation and dynamic competition in today's digital landscape. Our discussion in the workshop all emphasize the necessity of staying ahead of changing market dynamic. I was especially struck by the diversity of insights shared by all of the participants. Each unique perspective has enriched our collective understanding of global merger control trend. Our gathering here has allowed us to build a connection that will serve as a foundation for our competition work in the future. In fact, just an hour ago, the TFTC and the National Competition Commission of the Republic of Paraguay officially signed an agreement on the application of competition law. Therefore, I'm confident that this connection will aid all the ICN members in addressing the challenges we discussed. And I look forward to seeing how our future calls and regional meetings will deepen our shared commitment to effective merger enforcement. To sum up, I hope you have a chance to enjoy the beautiful city of Taipei and experience our local culture. Wishing you safe travels as you return home. the TFTC looks forward to reconnecting at future ICN events. Once again, I would like to emphasize that Taipei is a paradise for you to shop and eat. So spend your money as possible as you can until your pocket is empty. Thank you so much.
Thank you very much, Chairperson Lee. Distinguished guests, ladies and gentlemen, 2024 ICN Merger Workshop has successfully concluded. Thank you to all attendees for your participation. Once again, please present your badge to the staff at the restaurant on the first floor before you enter your restaurant. Thank you for your cooperation. Allow us to remind you, for a city tour this afternoon, please meet us at the lobby of this hotel at 2:10 p.m. 2:10 p.m. Enjoy your stay in Taipei. Thank you.